Well, Jim, thank you. That's, you drove down this morning. That's never an easy thing.
Well, it was exciting. There was a little wreck on 75, as there always is, so that meant that I was just tooling in the front door at about 8:29, and Pat was...
Well, he knows me that I have a little bit of a neurosis about people being on time. Did you all realize that? Yeah, I think the message has gotten across.
You notice his hands are still shaking on it.
That's my problem, not yours. Jim, I think it would be helpful for the students if you'd take a minute and just kind of give them a thumbnail sort of sketch of your career and the kinds of things that you have done, and then I'm going to walk you through some pieces I want to make sure that they hear about. I will say, by the way, that Jim and I recorded an oral history last year that's going to be up on Mercer's YouTube channel very soon. So if you want more detail about a lot of the things he's going to talk about this morning, that's going to be available for you. But introduce yourself, Dean Elliott.
All right, well, I was born in Atlanta, one of 3 natives as far as I can tell. Went to public schools. From there, went to Emory as an undergraduate. Stayed around for 3 more years in law school. Not because I'd always wanted to be a lawyer. It's just that in April of my senior year, it occurred to me that I was going to have to do something else. And that BAs were, at least you could get a job then, but it was not that great. And I had always thought I was going to end up at a little internet school in Cambridge, Massachusetts, doing graduate work in economics. But if you had spent 5 years there, you would have then become an economist. And that was sort of scary, so I looked around. I couldn't go to medical school because I had not had organic chemistry. I eliminated theology school, dental school, business school, and ended up in law school. After law school, I spent a short period of time in the U.S. Air Force. That was because I'd won the lottery. This was not the Hope Scholarship Lottery. This was one run by the Department of Defense, where if you won, you got 13 months, all expenses paid, in Southeast Asia. Fortunately, I was able to get into a crack military organization called the Georgia Air National Guard and tell my students that there were 600 applicants for 6 places. And I got mine on pure merit. And the reason I know that, my uncle, the Adjutant General, called to tell me that I got one of those 6. I have no apologies for that, folks. So I defended Dobbins Air Force Base just north of Atlanta for my time in the military. Went with a little firm. Actually, it was a little firm at the time. I was the 24th lawyer at a firm then called Alston, Miller & Gaines. Spent almost 30 years there. And had always sort of thought I'd like to go back into the academy. Did so. I'm back in the 90s, so it's been almost 20 years, I guess. Back in the academy teaching legal prof, real estate finance, and banking. During that time, during the time in private practice, spent a fair amount of time doing bar work, first with the Younger Lawyers Division, and then which was referred to then as the baby bar, and then with the big bar, I mean the rest of the state bar.
You know, one of the things that I thought you might be able to help the students with, because you have really in some ways a unique perspective. Being a young lawyer in a big, quote unquote big firm, commercial practice, you went through a training period that no longer exists. And I was wondering if you could describe what yours was, and then from the perspective of today, talk about how that contrasts with what a new graduate could expect going into a big commercial law firm in Atlanta.
Well, it's, I think, a very unfortunate change, because when I started there, you spent 6 months in each 6 different departments. So for your first 3 years there, you were actually in a training program. You experienced essentially the entire firm, at which point you were supposed to find yourself, decide what it was that you really wanted to do now that in theory you had grown up. By the time I left in the 90s, that had changed pretty dramatically. Instead of making offers to come with us, and spend 3 years in training and then find yourself, it was, there is an opening in the M&A section of the corporate department. If you're interested in doing mergers and acquisitions, we'd like to have you. Other than that, this job isn't there. And it was really economic forces, Pat, that got us there, simply because of the fact that even that far back, meaning in the 90s, clients had begun to realize that new lawyers, for whose time they were being charged $150, $200 an hour, really didn't know anything. Now, that was no different from when I graduated or when Pat graduated, but new lawyers simply were not worth $150, $200 an hour. Had a little client at that point who was headquartered in St. Louis. You may have seen their commercial at the Super Bowl. But the general counsel at Anheuser-Busch, even in the 90s, our deal was that he would pay for a partner, young partner, senior associate, and all the paralegals you could assign to his projects, simply because he had come out of private practice. He understood that paralegals were by far the best buy. Their billing rates were half that of young lawyers, and in all candor, they probably knew a whole bunch more. In the last few years, that's really spread, so that firms, not just big firms, but firms of all size, are being told by their clients, I don't want to see time on a billing sheet for anyone who's been there for fewer than 3, fewer than 4 years. That really changes things. Because before that time, think about it, a firm could hire somebody right out of law school, work them for 2,000 hours. I understand that they, during recruiting, may have told you 1,200, 1,600. It's 2,000 billable hours. Bid you at $200 an hour. That's $400,000 in gross income. They could afford to pay you $150,000 and $50,000 in benefits and still make a $200,000 profit. So that new lawyers could very quickly become a profit center. Now, when they cannot bid your time out, a new lawyer becomes a cost item, which is why many firms now, many governmental agencies, a lot of places, want to hire somebody who's had 3 years of experience. And of course, from your standpoint, you're sitting there thinking, that's great, how am I supposed to get that 3 years of experience in order to get to the point where I'm going to be a much more saleable product, if you will, as far as law firm, and by law firms I'm including house counsel, government agencies, all sorts of things. It's really a very different and frankly much tougher market now.
Well, I would expect one result is they hire fewer new law graduates. But having done that, do they invest in their training more since they're not having to worry about making money on them?
Well, they're going to spend some time on training. The difference is it's going to be so specialized. Instead of having someone who is going to get a general background, and say you're going to be hired to come in for a specific slot. So that if you took that M&A slot in the corporate department, you're going to get training, but it's going to be a very concentrated training in mergers and acquisition.
So get you up and billable sooner.
Get you up and billable as quickly as possible.
One of the reasons I wanted to make sure that you visited with us, Jim, is that until now and then continuing the semester, we have just like every other experience in law school, it seems to be a predominance of litigators. right? And it gives the students the impression that everybody goes to court. In fact, probably half of our profession never does. You were a transactional lawyer.
Right.
You were not a litigator. Could you talk a little bit about why you made that choice and what it was that you enjoyed about that practice?
Well, I do want you to know that I was a litigator specializing in federal litigation.
Here we go.
2 cases. First one was an appointed case of an alleged bootlegger from North Georgia. And that was my first year in practice. And my second year in practice was a case that was fortunately before a wonderful judge, Sidney Oslin Smith, who was at that time the chief judge of the Northern District, was later my partner at Alston and Berg. But that was for the Lawyers Committee for Civil Rights Under Law to see that the '68 Civil Rights Act was declared constitutional.
And you took 2-0.
2-0.
Declared
2-0.
victory and went back to doing deals.
Well, I figured at that point it couldn't get any better, so I better go do something else. What had really happened was that during the rotational period, I was spending some time in commercial real estate. Never occurred to me that I would end up there. But when I first moved into the department, 2 of the senior partners left to form their own firm. About 3 months later, 2 more of the partners left to form their own firm. So all of a sudden, as a second-year lawyer, I'm one of the more senior people in the department. And it's just sort of surprising. All of a sudden you're getting really good work. And that when PLI comes in town and they're going to put on a CLE, they look around and they figure they got to have somebody from each large firm, right? And so here I am in 26 years old, getting chosen to do a national PLI seminar for Alston, Miller, and Gaines, along with some really good lawyers from Sutherland and other places where I learned a ton, by the way, from doing those seminars. Learned it from other lawyers who were on the panels. So it was pure happenstance. Once you got started in something and you began to get good at it, or at least people thought you were, it became more and more fun. So I decided I wanted to do transactional.
Yeah, well, talk about what was fun about it. I mean, you did it for 30 years, and I mean, you obviously enjoyed it. I mean, well, I know why you left it, and we can talk about that, but you obviously loved what you did. What was fun about it? It wouldn't be fun to me. That's why I'm asking. Doing deals. I mean, what was fun about it?
That's the fun of it, is doing deals. In fact, I learned very quickly that the best new associates for me were the very detail-oriented. They were the tree people. I wanted to be the forest person. I loved doing the deals. To me, it was much more fun sitting at the table helping structure the transaction than it was doing all of the documents that were quite necessary to cause the transaction to be completed. So for me, it was just a wonderful setup. If I could be the deal maker and have younger lawyers around who, as you were flying back to the ATL, you talk about the deal knowing that they would do a great job on putting the first drafts of all the documents together, and that would be the next time you would look at it.
And unlike what I did, when you were practicing, people would leave the table happy, right? They would do, because
Yes.
they've made a deal that's in everybody's interest, and in litigating, everybody's mad, right? So is that part of it?
Well, for me, that was a major part, and I think it really depends on personality. I liked the fact that you could have a tough negotiation, a lot of money at stake, and at the closing, everybody gets up with a big smile on their face. Buyer, seller, borrower, lender, everybody was delighted with the transaction, and for me, that just worked better.
There's one story that you tell about being a young lawyer doing these deals, if I remember correctly, involved Macy's.
Yeah.
And I was wondering if you could share that story with the students, because I think there's a wonderful lesson in it, and it's a funny story.
Well, it's actually a really good lesson in professionalism that I used it in my own legal prof class. In the sense that, I had been there a fairly short period of time, and Philip Alston, at that time, he was not Philip, he was Mr. Alston.
Mr. Alston.
Philip, yeah. But in any event, he sticks his head in the office, said, you need to head home and pack, we're on our way to New York. And, this is pretty exciting, right? This was before TSA. You could actually go to the airport and get on a plane, and, it was fairly pleasant. So you're excited about going. Fortunately, my secretary, who had been there for a long time, knew to tell me to get a trip advance, because when you flew with Philip, the young person on the flight, on the trip, was the treasurer. You paid for all cabs, all tips, whatever. But in any event, I pack and we get on the plane, we go off to LaGuardia, and we show up in the offices of Macy's. I even still remember the guy's name. General counsel of Macy's was a guy named Marvin Fitz. And I will guarantee you wanted to be on Marvin's side. He was the toughest lawyer I think I've ever seen. Fortunately, I was on his side. But in any event, we'd gone in, and there was a name partner from another Atlanta firm who was there representing the purchaser. Somebody was buying the shopping center from Macy's. We had been at it for some little period of time, and Marvin sticks his head in and says, Philip, I need to see you. So Philip Alston gets up and he walks out, and we're all assuming, of course, it's only going to be a few seconds, but we keep talking. Well, it goes on and on and on. And keep in mind, this is a first-year associate sitting there. Ben Kohler was on the other side.
Now, how big of a deal is this?
Oh, at that time it was something that now sounds like peanuts. It was making, I don't know, $10 million, something like that. And now it would be $100 to $200 million. But in any event, we get to something, and Ben looks across the table and he says, well, we haven't talked about the intangibles tax. I know you're going to expect my client to pay it, so we're not going to spend any time arguing over that. Just, include that in the contract. And I shook my head knowingly, of course, that that's what was going to happen. I didn't have a clue what the hell an intangibles tax was. Ben knew that I didn't know. But he also knew that it was typical for his side of the table to pay it. Now, he could have left me hanging. He chose not to. Well, and in any event, Marvin and Philip come back in. They're very apologetic about having delayed things, and Ben looks up and says, we've got a deal. And they look surprised. And they're thinking, this first-year lawyer pulled this off, So all of a sudden, they're thinking of me as being some real hotshot. And yet, Ben Kohler was a guy who, as I say, he could have stuck it to me. I wouldn't have found out about it until some later period. It would have been highly embarrassing. In fact, when I got back, I had to ask my secretary. I said, Ms. Wallace, what the hell is an intangibles tax? And she explained it to me so that I wouldn't be totally ignorant about that in the future. But it's contagious. I will tell you that any number of times in the next 30 years, when I had an opportunity, like Ben had, that I chose the same thing he did. That you can act professionally and still be a good representative for your client.
And he didn't sacrifice his client's interest in it, but he just did it in a classy way.
Absolutely.
Yeah. Well, Jim, one of the other reasons I wanted you here this week in particular is that we've been talking about access to justice all week, pro bono and other issues related to access to justice. As I said in my introduction, you were there at the beginning. Could you tell the students a little bit of the story there about how it came about that you became interested in seeing that there were legal services available to the poor, and then how you did it?
Okay. I'd been in practice a fairly short period of time and had wanted to get involved with the state bar, simply because I've always been interested. If I were interested in an organization, part of the organization, I would really sort of like being a real part of it. So I had wanted to get involved with the Younger Lawyers Division and had gone to one of their meetings and had asked the then president, you know, how could I get involved? And he said, well, one of the hot things going on right now is legal aid, civil legal services to poor people. And he said, I was about to form a committee, would you like to chair it? So of course I did. And that resulted then in a study to find out just how many poor people there were in Georgia. To put it into current perspective, the population of Georgia is pushing 10 million. There are roughly 3 million who meet guidelines for poverty. That's a lot of people. But in any event, so we've got this legal aid committee, and we look at it and we say there's a crying need here. So a small group of 6 of us, 4 who were active in the bar, and 2 more that I knew were interested in legal services, got together, and we decided to form something called, at that point, Georgia Legal Services Program. Now, keep in mind, this was early 70s. Legal services to poor people were not at the top of the agenda of the Board of Governors of the State Bar, which is speaking about as euphemistically as you could possibly speak, since we were referred to by a number of those as being pinko commies for wanting to help poor people. In any event, Middle Georgia had a lot to do with this, by the way, because 2 of my mentors, one lived just up the freeway in Forsyth. His name was Harold Clark. He happened to be the state bar president same year I was president of the Younger Lawyers. And Cubby Snow Jr. was right around the corner. But they had our back in that this was not a program that was popular, and oddly enough, most people have long since forgotten. The only way we could get it approved was to have the Board of Governors of the State Bar as the Board of Directors of Legal Services. Fortunately, we were able to persuade them that there needed to be an executive committee that would have more day-to-day control, and that was primarily younger lawyers who were not on the Board of Governors. And every annual meeting, if you ever go to an annual meeting in the State Bar, one of the business sections is where you're appointing auditors and bondsmen and all sorts of other things, and people are sitting there reading the paper and just voting aye, aye, aye. And that I would introduce a motion to approve all action taken by the Executive Committee of Georgia Legal Service Program during the preceding 12 months. Aye. And we'd go on. And I think if they had had any real idea or had taken the time, because there was a report there, to know that we had done such foolish things as class actions against CNS Bank, which was a predecessor of Bank of America, they probably wouldn't have been that excited. But those 6 idealistic young lawyers, having formed that organization, it's provided legal services to almost 1 million people since that formation.
I know you well enough to know that this didn't happen just because you happened to get appointed to that committee. I mean, this is something that's personal to you. Why was this issue important to you? You didn't grow up poor. Now, you didn't grow up wealthy, I know that. You didn't grow up poor. Why was this important to you personally?
Well, I think probably it's, it's amazing that you'll start looking back pretty soon and find out that you learned more at your mama's knee or daddy's knee than you remember. My parents were children of the Depression. They came through at a time when my maternal grandfather, for instance, for some period of time, put newspapers inside his clothing because the only job he could get was delivering newspapers. And that was the only way to keep warm in the winter. So that, my mother's side of the family really did struggle. My father's side of the family, 8 kids, and how my grandfather got 8 kids to Berry Academy in Rome, Georgia. I'll never know. My father was the only one who finished there, but all 8 at least spent some time there. These were folks who lived on a farm in Henry County, McDonough. And my grandfather was the editor of the weekly paper and a school teacher, so there was not, again, a ton of money. And I guess I just grew up with some sensitivity that there were people not as fortunate as others, and that if you were lucky, you had an obligation to help out.
From a notion of idealism, which I think is what you just described, to the pragmatism of actually getting things done, I want to move to how Georgia Legal Services and Legal Aid got a big part of their funding. And here, of course, this is coming from the interest on lawyers' trust accounts.
Right.
1 million people have been served by this program. They couldn't have been served without money. Getting the money is not an entirely idealistic just dream. You have to do some pragmatic things.
Well,
how did it happen?
I can talk about it now because, as far as I can tell, Pat, all the statutes of limitations have expired. So, when I'm about to acknowledge,
As your attorney, I advise you can speak.
Okay, I can talk. Okay. Back in the late 80s, primary funding source for legal services has been the federal government, but that was beginning to shut down. Still a lot of poor people, still real need for Georgia legal services. And I'd heard of this program that was started in Florida called mandatory IOLTA. So, being the astute politician that I thought I was, I had gone to each member of my executive committee to talk to them, all of whom had agreed to support the kinds of mandatory IOLTA, interest on lawyer trust accounts.
Yeah, you may need to explain exactly what that is.
What that does is it requires that lawyers put their trust account monies only in institutions that agree to pay interest on that. Up until that time, lawyers' trust accounts, banks kept, paid no interest on it. Needless to say, bankers loved it because that means their cost of funds was zero for all of those deposits. And particularly for firms that do a lot of real estate work, you can have a ton of money in an account at any given time. Well, it turned out when it came up for a vote that most of those folks had rethought the issue and determined that mandatory IOLTA was not something they ought to vote for. And I was fairly bent out of shape about the whole thing and was lamenting the fact to, again, my mentor, the Honorable Cubbage Snow Jr. And it's a question of who was leading, who was straight. But in any event, the two of us decided we'd go see the Supreme Court. So we went over, and it was Tom Marshall, who was the CJ, and Harold Clark again, who was the PJ, and a guy named Charlie Waltner, who were 3 of the 7 justices, and we're meeting with them and saying, one, that there's this critical need for services to poor people, critical need for funding for that, and there is a mechanism, mandatory IOLTA, that the court could adopt that would fund a major, major part of legal services. The fact, by the way, that since that time it has raised over $100 million, most of which has gone for legal services, tells you it was really important. In any event, it was not normal for the court to do things on its own motion. And the chief looked across and he said, well, how long is it going to take you to get this through the Board of Governors? And I said, well, Chief, I think it'll be about 35 years. And he laughed and he said, no, I'm serious. And Harold Clark, who, as I mentioned, was a past president of the state bar, looks and says, Tom, one, he's serious, but two, he's grossly overly optimistic. There's no way in hell he could get this done in 35 years. So the chief said, are you asking this court on its own motion to adopt mandatory IOLTA? And the answer was yes. And they did. By a 7-zip vote. Now there's a lot of stuff that I'm leaving out in between, but the court adopted mandatory IOLTA. And as I say, it's raised $100 million for legal charities, most of which are legal services. So there are often more ways than one to get something done.
Yes, indeed. Now, Jim, you're going to sit in with Section 6 later today as they do this week's exercise. But the exercise involves a mock meeting of the Board of Governors and talk of mandatory pro bono for lawyers and mandatory pro bono for law students, as New York, has done. One of the things that comes up in these discussions is the question, and I raise it if the students don't, whether lawyers bear any special responsibility to see that folks who can't afford access get it, as opposed to society having,
Sure.
The role. Is it our job? If it's our job, why is it our job? And then we can talk about details about how to accomplish it. And
Okay.
I was wondering, what's your reaction to that? And do lawyers have a special responsibility apart from everybody else in
I
society?
don't think there's any question about it.
Tell me
We
why.
do. Simply because, think about it. The court system, the judicial system, belongs to the people, right? Not to us, not to lawyers, not to judges. It belongs to the people. What they have done is to give you soon, Pat and me already, an opportunity to be part of an oligopoly. We have very special privileges as it relates to the judicial system. Now, it seems to me that it is perfectly fair for citizens to say, in exchange for that, and granted you've earned it, you've gone to law school, you've passed the bar, but I still think it's fair for society to say, you have a special obligation, not just a special opportunity, to see that people have access to justice. Let's face it, if you look at the criminal justice system, there is no question in my mind, at least, that the criminal justice system is fairly biased in favor of those with money. And by the way, I could not afford to go see some of the really good criminal lawyers. You couldn't either. But if you've got tons of money, you can go see Don Samuel or Eddie Garland or Jack Martin or any number of other really good folks. If you don't have money, particularly if you're on the bottom end of the pay scale, you have a constitutional right to have counsel appointed for you. So in the criminal justice system, in spite of the fact it's skewed a bit toward money, you at least have the opportunity of having counsel, somebody there representing you. It doesn't exist in the civil justice system. Is it a responsibility of society, meaning should the General Assembly of Georgia fund legal services? Yeah. I think that's perfectly appropriate. Are they going to do it? No. I think it's perfectly apparent. They got a ton of demands on their money. And let's face it, helping poor people hire lawyers is not really high on the priority list. Those from Atlanta, by the way, the highest thing in the priority list right now are salt trucks and other things like that. Since my commute on Tuesday was 4 hours instead of 30 minutes, and mine was speedy. Okay, so let's take the assumption that the General Assembly may have that obligation, but it is highly unlikely that they are going to put a significant amount of money in. That leaves us. I think we have an obligation of seeing that those services are provided. We could do that a couple of ways. We could all volunteer time, which again is probably not the most efficient way, and again is not likely to satisfy all the needs. Or lawyers could be asked to help fund it, meaning with additional bar dues. And as you can imagine, that is not a popular concept with most lawyers. But I think we have that as an obligation, and have encouraged the court that it consider a dues increase with the entire increase going to support legal services.
Well, Jim, your students and mine have at least one thing in common, and that is many of them carry enormous debt.
Yes.
And so they graduate having worked so hard and spent so much time, having forgone so much income, having borrowed so much money. And I think it's a fair question from somebody in that position to look at you and me at our stages in life and our comfortable circumstances and say, it's easy for you to say that I ought to do pro bono and I ought to contribute money, but why is that fair to me, given that I'm just starting out and I'm already carrying this kind of debt? What would you say to that student? And I bet there's a few of them in here who would say that.
Well, I'm really glad you raised that for two reasons. One, because I'm going to piggyback on it to ask your students for some help.
Okay.
But first, I'll even try to answer Pat's question. I have great concern, as I know you do, about students graduating with so much debt. I had a student not too long ago come by to ask me to help calculate what his monthly payments will be on his $200,000 in school loans. I mean, that's a mortgage on a house, but you don't have the house on you guys, the mortgage. I mean, that's incredible. Yes, it's going to be tough, but it seems to me you're still going to be a part of an honorable profession, and you still have that obligation to pay. Now, if you let me take 2 minutes and
This is your show, Jim.
all right. What I'd love to hear is your response to a proposition. Hypothetical, of course. As of now, to take the Georgia bar, you have to have a BA degree, 3 years in an accredited law school, and then you take the bar. What if there were an alternate route to the bar exam? That one would still exist, but there would be a second route. That would be a BA, 2 years in an accredited law school, a 1-year supervised internship, and then you take the bar. When I've asked my students, and then I want to ask your students, how many of you would consider that second alternative?
Okay, for purposes of the recording, I need to report that if it's not unanimous, it was very close to unanimous.
So now Gary is shaking in his office just on the thought, because think of the impact that has on a law school with potential of a third of your gross revenue disappearing. The lightning is going to strike soon, by the way, because this is heresy in the academy to consider that if that were to happen, you might even find that tenured profs no longer had jobs. So this is scary. Now, is that my goal to try to see tenured profs fired? No. The goal is to give students the opportunity. If you were now borrowing $50,000 a year, think about it. If you only had to do that for 2 years instead of 3 years, you'd still have a fair amount of debt when you got out of here, but it would be a third less. Instead of 150, it would be 100. Whatever the numbers are appropriate for you. And I think what that will force law schools to do is to determine how to make the third year more relevant. If I'm going to try to persuade you to come back and borrow that extra 50, then I've got to provide you a curriculum that's a real benefit to you. And being a cynic, I will say to you, I'm not convinced that law schools, and I will start with mine, provide that much value in the third year. Ton of value in the first year. A little less value in the second year. I question the third year. And this would give you the opportunity, and particularly if you found that government agencies, for instance, would start saying, requirement is not a JD, but is admission to practice. If law firms would start saying, we may actually prefer if we can bring some of those interns in and have them spend a year with us, we get to train them. We know that they're good, and I would think they would be much more likely to want to make a major part of their hiring process bringing these interns in.
Well, Jim, since you're somebody who saw that there was no such thing as Georgia Legal Services and no way to fund it, and A, it exists, and B, $100 million was raised, far be it from me to say that your vision, right, could not come true. I think that is something obviously that's being talked about, maybe not in your lifetime or mine, but it's being talked about, and maybe sooner than that. What I'd like to do...
It's being talked about more than you know.
Actually, I do know. But they're not supposed to know. I'm kidding. What I'd like to do now is we've got about 10 minutes left.
Okay.
And I would like to open it up to the students to ask you about that or about anything else that they want to ask you about your career or anything that you've talked about. Yes, sir.
I really like the idea about law school being 2 years. I guess my question is this: for private schools like Mercer and Emory, we don't have the benefit of the state subsidy keeping costs down like they do at UGA and at Georgia State. So what does that do to us?
What would your idea do to a private school like Emory or Mercer?
Well, what it's going to end up doing is that private schools like Mercer and Emory are really going to have to reconsider their third year curriculum in order to try to make it attractive to you. There are other things they could do. They could increase scholarships, which I doubt any of you would object to. They could find ways to lower tuition. It's no secret that tuition in education, not just law schools, but in general, has been going up for now decades at 2 or 3 times the rate of inflation. Again, I'm a heretic in that I don't think that, 1, is sustainable, or 2, is adequately explainable. I can come up with lots of reasons why I think it's happened. But unfortunately, a great part of that was because you could borrow that money. There hasn't been any incentive on the academy to contain cost, because as long as students can borrow everything they need. And that worked up until about 4 years ago. I don't think it works anymore. The 202 accredited law schools are graduating each year something in excess of 40% of their graduates who will not find JD required jobs. A lot of those students have that $150,000 in debt, and it's going to become excessively burdensome. And as you all know, that $150,000 $50,000 you may have debt, whatever the amount is not dischargeable in bankruptcy. I mean, it's there. So I think if this proposal were to be adopted, it would scare the hell out of private schools more so than it would state schools, simply because the tuition is so much more here and at Emory than it is, as you point out, at Georgia State. But it could impact them as well, because they would still be losing at least a third of their tuition income. They've got a big supplement from the state, but they would still get a real economic hit unless they could adjust their curriculum to persuade you to stay.
Other questions? Yes, sir.
Okay, a hypothetical lawyer goes to work for Georgia Legal Services, does 3 or 4 years, gets their stripes, and then wants to go into a firm. Is that person going to be looked at by other lawyers as a pinko, something you mentioned earlier, as an idealist and have an aura around them?
Okay, for purposes of the recording, basically the question is, if somebody gets their first few years of experience in Georgia Legal Services, does that create an impediment or an obstacle to being hired by a law firm because of perception that they are idealistic?
Well, for some lawyers it would. I would hope there would be at least an equal number of lawyers who would find that to be a very positive thing, that somebody had a concern for other folks. Would the experience you got doing legal services be directly applicable to what you would be doing in private practice? Not completely. Because a lot of the things you would be doing, landlord and tenant work, other sorts of things, you would be much less likely to do in private practice. But you would still have had the day-to-day contact with clients. In fact, the day-to-day contact with clients you would get in a legal services operation is much higher than what you would get in a private law firm. Would it have been better if, for instance, you had spent that 3 years at the 6th District Federal Reserve on their in-house counsel staff before you went into private practice? Probably. In the sense that law firms that did banking work would love to have somebody who had spent 3 years at the Fed or the OCC or something like that. Would it be very good legal experience? Yeah. I don't think there's any question about that.
Other questions? Yes, ma'am.
It seems like you have a very strong inclination for public service and public interest work, and I think a lot of us in this room share that, but we also might have personal interests in corporate law. So I guess at the beginning of your career, how did you reconcile that inclination for public service work with choosing a path in corporate big law?
How do you reconcile or combine interest in helping the poor and doing big-time corporate work?
It's a perfect mix. I have great respect for people who do the legal services. I wanted it both ways. I wanted to feel like I was helping in that area, but I loved the practice in big law. And was lucky, by the way, in my particular firm. I don't know that it would have been true in every big firm, but for instance, when I did the Lawyers Committee for Civil Rights under law in the 60s, that was not one of the prime representations of most big law firms. And yet, when my firm found out what I was doing, I got a visit from 2 of the named partners to say, we're delighted that you're doing that. These are the sorts of things lawyers ought to do. So it made it a whole bunch easier to do both. I don't see them as being irreconcilable. In fact, I'd written an article once that said you can do good while you're doing well, and I think that's possible.
Other questions for? Yes, sir.
Yeah, one of our debates coming up for next week is about legal technicians. The idea of, that's, I think, is already in place in Washington State for people to be like a nurse practitioner to a doctor. And the question of whether or not that would cheapen the profession, or if that would just allow an increased access to legal services if you had people who were trained for just 2 years or less to deal with family law or things that were less complex. What are your thoughts about that? Is that a productive advancement?
I think it makes all the sense in the world. One size doesn't fit all. There's no reason that we cannot provide really good training for folks who are going to be in a particular specialty area. I will tell you that my experience with paralegals in my own firm was that they were at least as bright as the lawyers. They were specialized. You know, they were not trying to be general practitioners. They were in a specialty. They learned it very quickly. In fact, the ones we hired had already gone to a paralegal school. And just as the general counsel at Anheuser-Busch wanted as many paralegals on his jobs as possible, there's absolutely no reason that we can't have training opportunities for people who want to become experts in landlord-tenant law. Or for that matter, it could be, you know, representing Social Security folks. It could be in representing veterans. Critical need for folks who have come back from Iraq, Afghanistan, whatever, and where it may take them 18 months to begin getting disability payments. There is no reason that you couldn't take bright people and train them very quickly on how to represent those veterans. And primarily what it would be is helping them fill out the mandatory forms. But I think it makes a ton of sense. Now, will there be lawyers who object to it? Yes. They will look at that as competition, and for some it would be. But again, don't we have an obligation as a profession to do what is necessary to provide access to justice?
And the students are going to be blogging by Monday in each of their sections about this question. I may share with you some of the responses.
Good, I'd love to see them.
Jim, I wish we could continue this, but we're out of time for this part of your visit to Mercer today. But join me in thanking Dean Jim.